And without any further ado, here is the formal introduction. So today's online learning session is on the International Criminal Court, the ICC, and humanitarian actors. The learning objectives for today's session include a review of the relevant humanitarian principles, and in particular, neutrality and independence, and how these apply in the context of potential cooperation with the ICC. There will also be an examination of the possible roles that humanitarian organizations may play in either investigations or prosecutorial efforts undertaken by tribunals such as the ICC, and what benefits and risks this type of cooperation may entail. There will be a brief introduction to the context, goals, and methods of fact-finding and/or information gathering activities, as is commonly undertaken by humanitarian organizations. There will be an analysis of the possible impact on these organizations based on their undertaking such activities. And lastly, there will be a discussion of potential challenges and responses to this interaction by humanitarian organizations with the ICC. And so with that, I'm very pleased to welcome Theo Boutros, who is an independent consultant in international human rights and humanitarian law. And he will be with us today for the presentation. So with that, I will hand it over to Theo. Welcome, Theo.
Hi, everyone. Good afternoon, good morning, or good evening. I hope you can hear me fine.
We can, yes, thank you.
Okay, great. Just a disclaimer, I'm kind of new at this format. This is the first time I'm using this format to discuss an issue like this one. So I'm going to be trying to be as engaging as possible, but maybe I need a bit of warm-up. Maybe with regard to the topic of today, the International Criminal Court and humanitarian actors, I'd like to start with an anecdote, because this is a topic for which all of you has expectation, assumptions, prior experience, positive or negative. And once I was working for a human rights NGO in a war zone and doing human rights investigation, and I had to arrange a meeting with a rebel commander in a territory controlled by this commander. And the first thing we had to do was to actually do a lot of preparatory work to establish trust, to make sure that our organization would not be confused with the UN, which was actually at the time engaged in active combat against that armed group. So this was the preparatory work, which is directly related to our session today in terms of trying to mitigate misunderstanding, both on the side of the ICC and on the side of humanitarian actors on the respective roles and mandate and limitation of those two institutions. So this anecdote was about meeting this rebel commander who wanted to discuss allegation of human rights violations with us. And actually most of the meetings ended up being about the ICC and him being concerned that he would end up in front of the ICC. So there was a lot of damage control to do in the course of the meeting, because each time we were trying to talk about something else than the ICC, you would see that as maybe a way to gather information that could be incriminating him as a superior and commander of this armed group. So this is an example of the many type of perception you may encounter in the field when dealing with those situations. Now, I'd like to start with trying to map a bit further this complicated relationship between the ICC and humanitarian actors. I entitled that relation status. It's complicated basically, from my experience and from what I could understand, one of the problems is that in this relationship, there is, of course, in principle, mutual respect, because both institutions are pursuing invaluable goals and activities. One for the ICC with regard to contributing to the fight against impunity, and for humanitarian actors, depending on their mandate and their field of intervention, protect civilians, provide assistance, etc. But with those type of respect comes a lot of tensions, a lot of apparent irreconcilable differences, as I call them. In terms of mandate, as a start, talking about prosecution, talking about criminal responsibility, talking about an institution that may be perceived as having a lot of power, depending on where the person stands. Basically, prosecution and investigation could be seen as goals and mandates that are contradictory to what humanitarian actors, try to achieve. By this, I mean, for example, that humanitarian actors, depending on their mandate, might be focusing on getting the greatest access to vulnerable groups. And for that purpose, if they start including in the discussion, directly or indirectly, consideration of prosecution and criminal proceedings, this might actually hamper, if not destroy, the relationship they built with all the actors on the ground. Methods of work are also very different. Usually people would see, and humanitarian actors in particular, could see the ICC as working under very rigid procedural methods under international criminal law that leave very little space to flexibility, flexibility which is required in such contexts to carry out activities. So for that purpose, maybe humanitarian actors would see the ICC as an actor with so many constraints and limitation that that there might not be an avenue to explore in terms of cooperating with the ICC. The goals are different. We also said that. The context as well. Humanitarian actors would be more on the ground, operating under different security protocols, and for that matter, the ICC would actually need to rely a lot on them. But the moment the ICC would try to approach humanitarian actors, they would see that as a potential risk for their activity. So a lot of room for misunderstanding, for misconception, and also, let's be honest, real and true dangers for their respective work. But actually, there's also a lot of potential for complementarity between the two set of actors, and there's also actual complementarity. I mean, I was right before the start of this session, while listening to this beautiful melody, I was reading some of the comments by the people in the chat, and people were saying, I have experience with the ICC, being in the medical field, for example. So there is definitely complementarity. The first one I see, which is an obvious one, is the fact that humanitarian actors are most of the time the first responders, so they have a privileged position in terms of accessing information that are not information you can call evidence at this stage, because those humanitarian actors will be something else than collecting evidence. Although if you have a broad understanding of humanitarian actors, you would include in those actors human rights organization, which purpose is to gather data on allegation of human rights violation or international humanitarian law violation. So there is definitely a need for the ICC and humanitarian actors to learn to live together, and maybe opportunities for cooperation will be more obvious for certain humanitarian actors rather than others. I mean, I think of one of the questions we received prior to this session about the monitoring and reporting mechanism under the UN Security Council mechanism with regard to grave violation of children's rights, where this mechanism of data gathering might actually be very useful for the ICC purpose of gathering information, or at least getting some leads that would generate the need to gather evidence on particular incidents. So definitely, depending on the mandate, opportunities or entry point, if you want, in terms of cooperation, might differ from one humanitarian actor to another. Humanitarian actors having very different mandates. I can take a very practical example as well. If you look at purely humanitarian assistance-oriented actor who would be doing needs assessment in an IDP camp, in an internally displaced person camp, gathering information on the patterns of displacement and the needs of people could be seen as valuable information from the point of view of a prosecutor, especially at the ICC, with regard to gathering information on the crime of forced displacement. So even in that context where maybe we might not see, in a way, a connection, there is actually a very valuable one. Now, with regard to the outline of this presentation, I'd like just to get an overview of the various types of relationship and cooperation that may happen. I'll try to do that, of course, not exhaustively, but look at both the ICC perspective, how the ICC sees cooperation, and what are the various modalities of or forms of this cooperation. Then I will try to look at this question from the perspective of humanitarian actors. Then we will be looking at risks and challenges for humanitarian actors arising from that cooperation. That might be voluntary, because humanitarian actors could proactively seek cooperation with the ICC as part of their formal mandate to contribute to address accountability and impunity issues. And maybe, of course, we can come back to some of those risks and challenges in the Q&A session. And then maybe ask question, how about addressing this cooperation from the angle of good practices? Maybe move away from this dilemma of cooperate or not cooperate to try to consider ways to move forward where actually using existing avenues and maybe better understanding of what this cooperation may mean to actually strengthen the existing mechanism of cooperation. In terms of forms of relationships, from the ICC perspective, without being too technical, I think it's important from the start to consider that depending on the stage of the ICC proceeding, whether this is at the preliminary stage, whether this is before the pre-trial chambers, or at the trial stage, the standard of proof required will be different. And the closer you get to the trial phase or the trial phase itself, the more demanding the standard of proof will be. Standard of proof being the specific degree of certainty required or used by the prosecutor or by the judges to come up with a conclusion. And for that specific issue, if you look at the early stage of the procedure where you have the lowest standard of proof, which is in one case when the ICC prosecutor requests to open an authorization, to open an investigation, requesting that from the ICC judges, the standard of proof is very low at this stage. This is reasonable basis to proceed on investigation. And in that context, the prosecutor is using a lot of secondary sources, mostly public reports from NGOs, from humanitarian actors, from UN agencies. So even if humanitarian actors do not want to cooperate, at this stage, the ICC work itself would require the prosecutor to rely on those sources, which are public, and this can trigger follow-up processes by which the ICC will get in touch with the relevant humanitarian actors. We'll come back to that probably later and maybe in the Q&A question. Now, another thing I want to stress right away is the fact that, and that's sometimes misunderstood, but that's a fact. The ICC is trying to strike a balance between consideration for protection and confidentiality of information or witnesses or victims, with imperative to respect the rights of the accused and the standards to ensure a fair and impartial trial, as well as considering the needs of all victims. So most of the time, either existing cooperation mechanism or modalities, or discussion around cooperation between humanitarian actors and the ICC revolve around, if you want, this balance, either trying to insist more on confidentiality and protection, but then the ICC also being bound by this imperative to ensure respect for the right to a fair trial, which is the case, for example, with regard to the obligation from the prosecutor to disclose the name of witnesses to the defense, and the possibility for the defense to cross-examine witnesses. It's very criminal law oriented, but that's a consideration that can't be dismissed. Having said that, I think it's important to try to get a sense of how the ICC would consider the roles of humanitarian actors. As I said earlier, humanitarian actors and, for that matter, public reports or documents published by humanitarian actors will serve as secondary sources with a certain probative value. For example, at the stage of gathering, of the prosecutor gathering information to be able to request from the ICC judges an authorization to open a preliminary investigation. Now, the ICC is also considering, from a more technical point of view, individuals who would facilitate the work of the ICC. In the ICC jargon, they're called intermediaries, and that's an institution that has been used a lot by the prosecutor, be it to be introduced to victims or witnesses on the ground, because intermediaries would know the context better, and they would be operating under security protocols that are more flexible than ICC investigator. But of course, the greater the role of intermediary is, the greater the risk is that intermediaries will be playing a role of quasi-ICC investigator, although they are not. They don't have this status formally or even informally. And intermediaries could be local staff working for humanitarian institution or organization, so having two hats, and this can create problems on the ground. Humanitarian actors would also be seen as providing information on the context of the crime. If you want information, the ICC prosecutor would need to get a better sense of maybe the ethnic of a country, related tensions, context with regard to sued by this understanding of the context, particular armed group and motives, and could also be direct eyewitnesses or expert witnesses. If, for example, you take some of the staff working for UN agencies, they might have, for example, an expert knowledge of the organization for the prosecutor to gather information on group, the responsibility and the mode of liabilities of the various commanders within the
Hello all. Just a quick mention here, if you don't mind. Like I said, and hopefully jinx us, but it appears perhaps I did. We're going to call a TO on the backup line, just so that we can ensure that a strong line.
Hello?
So if you will just stick with us. Hi TO, it's Beth.
Hi. Sorry.
Hi there. Sorry, the other wasn't great. So if we could just ask you to perhaps pick up on this line, go back about 45 seconds or 60 seconds or so.
Yes, no problem. Can you hear me now?
Yes, I can. Thank you.
Great. As I was saying, I think humanitarian actors can also be considered, and this is coming from experience on the ground, as direct eyewitnesses or expert witnesses that can provide valuable information to understand, for example, the organizational structure of an armed group. But humanitarian actors can also be direct or indirect victims. So that's something the ICC would consider as well. But maybe there's also a need to look at the ICC framework, at the ICC statute, not just as a framework that would be about compelling witnesses to testify or disclosing confidential information, which would be actually oversimplification and misunderstanding on the working of the ICC. For example, the ICC statute provides mechanisms to encourage witnesses to testify or provide evidence. Take the example of Article 54, paragraph 2 of the ICC statute at the investigation phase, where the prosecutor may, of course, request the presence of question persons being investigated, victims, and witnesses, seek the cooperation of any state or international organization, including the UN. But the prosecutor may also agree not to disclose at any stage of the proceeding documents or information that the prosecutor obtained on the condition of confidentiality and solely for the purpose of generating new evidence. So in that case, the information that might have been provided by a humanitarian actor would be used to for the prosecutor to get leads or where to look for his or her, in current case, her own evidence. And also the prosecutor can take necessary measures or request that necessary measures be taken to ensure the confidentiality of information or the protection of any person, for the preservation of evidence. Another example of those ICC mechanisms is the protection of the victims and witnesses. under Article 68, there is a provision related to the prosecutor that can take measures during the investigation and prosecution of such crimes. But as you can see, Article 68, again, these measures shall not be prejudicial to or inconsistent with the rights of the accused and a fair and impartial trial. So again, this need for balance between those two imperatives. Now, from the humanitarian actors' perspective, as I said, there's an issue of perception. Not to say that all humanitarian actors have a negative perception of the ICC. I'm not saying that at all. But it's true that from a humanitarian actor, looking at the ICC would be looking at the information the humanitarian actor is gathering. The ICC would turn this into evidence. And will this come all the constraints and the requirements of international criminal law and the respect for the right to a fair trial? They could also see the ICC with regard to cooperation, the fact that the ICC would rely too much on intermediaries that could actually maybe confuse the various missions of the respective actors, and then on the ground humanitarian actors with the ICC relying more and more on individual on the ground would see their work hampered and undermined. And also, as I said, there is this risk of being compelled to testify, which for many humanitarian actors make them reluctant, depending on their mandate. Okay, some of those NGOs could be proactively seeking that, but others would be reluctant to appear before the ICC with regard to safeguard of their principle of neutrality, independence, and impartiality. But as I said, there's also a positive role of the ICC in that this is an institution, a permanent institution, that is contributing to the fight against impunity. And as I said earlier, I think there is a need for humanitarian actors to see that the ICC on its own will be using public reports, even if humanitarian actors do not want to have anything to do with the ICC. The moment they publish reports, these reports might be used at a certain stage, early stage of the proceeding. Now, with regard to this big question of can someone be compelled to testify before the ICC, I think there's a distinction to be made first, which is about the distinction between being compelled to testify, to appear before the ICC, and testifying before the ICC without being forced to identify and name your sources. This was addressed in the case before the Special Court for Sierra Leone, the Brina case in 2006, where there was a recognition of the need for confidentiality of sources. With regard to whether or not someone can be compelled to testify, the general obligation of states to cooperate with the ICC under the ICC statute includes the fact that states should facilitate the voluntary appearance of persons as witnesses or experts. This is a voluntary appearance. But unlike the case of the ICTY, the International Criminal Tribunal for former Yugoslavia, which could summon and force someone to testify, this general obligation of state to cooperate with the ICC could be seen as a sign that the court itself doesn't have this power, and that it has to request a state to ask a witness to appear. But there's a debate about that with regard to whether the ICC itself has this power. And in a recent case in Kenya, Kenyan situation, in the Ruto San case in 2014, there was a recognition that through the state, the ICC was requesting witness to appear, and that the obligation to cooperate would render each request compulsory. Now, I was asked to address the fact that for the ICRC, the International Committee of the Red Cross, there is a specific recognition of the privileged status of testimonial immunity. This was already recognized by the International Criminal Tribunal for former Yugoslavia, where the ICRC was recognized with an absolute privilege to withhold information and cannot be compelled to testify or produce evidence of any kind. But this privilege was considered limited only to the ICRC on the basis that it is it has a unique status among humanitarian organizations. It has a status which is recognized in international humanitarian law treaties, and it functions through a very strict confidentiality rule. Now, this privilege is also recognized in Rule 73 of the ICC Rules of Procedure and Evidence. But it doesn't mean that this privilege is only for the ICRC, because there is an option also in Rule 73 for other humanitarian actors to be able to request that confidentiality be respected and argue a case about this. Very technical, but it should not be forgotten that the ICC statute is not the only legal instrument with regard to governing the proceedings before the ICC, and the ICC Rules of Procedure and Evidence contain in Rule 73 the possibility for other actors than the ICRC to benefit from the confidentiality. Risk arising from cooperation. I'm not saying this is an accurate general statement, but it's kind of true to say that the actual cooperation might be less threatening than the risk associated with this cooperation. We can come back to that in the question and answer session. But we need first to recognize that the ICC is operating under a principle that are kind of similar to those used by, relied on by humanitarian actors like impartiality and confidentiality. But this is again an issue of perception. If you're operating in a country where any international organization is seen as part of the ICC, of the UN, even if it has nothing to do with those, you need to work around those perceptions rather than about what is actually true. Because those type of perception, such as the fact that the ICC is a politicized body, or that, for example, let's face it, if the ICC only has cases against non-state actors and none of those cases relates to commanders in the governmental armies of the country, the fact that the current caseload for the ICC is only against one party to the conflict can be sufficient to consider the ICC as biased, whereas those considerations might be related to other factors. Now, in terms of good practices, I think we need to consider internal and external practices of humanitarian actors. I think there's a need to better understand and use the confidentiality rule that I just talked about and all the measures provided by the ICC legal framework on the part of humanitarian actors to see when they decide to cooperate, to have a plan and to have a very good understanding of what this entails in practice. That's very important. So to what extent the obligation of disclosure from the prosecutor might be limited based on confidentiality, on the confidentiality recognized to humanitarian actors. Another point to consider is about improving data collection methodology. Not that the current methodology is bad, but it's interesting to look at the case law before the ICC, where the prosecutor was criticized in several cases, including Lubanga and Bagbo, for having relied too much on hearsay and anonymous testimonies from NGO reports or UN reports at the stage or at the preliminary stage of the proceedings. And in a way, if the methodology in those public reports, I wouldn't say is in line with international criminal standards, because that would be a complete misunderstanding and that would be wrong. These are two different things. But with regard to the methodology, maybe there's a need to consider what happened before the ICC, what type of methodology was criticized by the ICC when it relied on information provided by humanitarian actors, to take this into account and to see to what extent it could influence the methodology. And finally, this is something which is sometimes seen only in the context of course, of the humanitarian actor carrying out an activity. But when the humanitarian actor or when the ICC are working, they are these activities are governed by the do no harm principle, which is ensuring that the activity carried out will be causing the least harm possible to the person the humanitarian actor or the ICC is getting in contact with. And for that matter, when you seek informed consent from someone being interviewed, whatever the context of the interview is, if it's outside the ICC framework, if you look at humanitarian actors, informed consent would be about explaining the mandate, explaining how the information will be used, and seeking, based on this full information, seeking the consent of the person for the use of that information, be it the use of that information provided that the person is not named, or even not using that information at all. But maybe there's a need to consider also that depending on what can come afterwards, there's a need to consider whether, depending on the humanitarian actor, depending on the mandate, there's a need to, if the humanitarian actor knows in advance that there might be avenues to cooperate, to also consider informing the interviewee when discussing this question of informed consent, of the possibility that this information might be transmitted to a prosecutor or to the ICC, and that might, depending on the situation, end up with this person having to testify. On that note, I think I will leave it for now, and I'm looking forward to discussing those issues further in the Q&A session. Thanks a lot for your attention.
Great. Thank you very much for that. Very interesting presentation. We have a number of questions that have been coming in, very strong questions. The first I'd like to do, Theo, is from Jamal. And Jamal asks, is it possible for humanitarian actors to provide evidence to the ICC without them being named or identified, and perhaps to appear in the witness box?
Sorry, could you repeat this, because can you hear me?
Yes, yes. Sure, do you repeat it? Was there a bit of interference there?
Yes, yeah, the connection was not bad. Not bad, actually. Sorry.
Okay, great. You know what, Theo? I'm hearing word from Marcus. Perhaps if you could mute the sound on your computer that you're just on the phone. We might be better. But here's the from Jamal. Is it possible for humanitarian actors to provide evidence to the ICC without those actors being or otherwise identified and also having to appear in this box, perhaps?
Yes, thank you. Well, there is. If you look at the mechanism in place in the proceeding, again, there is a balance between protection of information and confidentiality and securing the rights of the accused. But there is a possibility under the rules of the ICC rules of procedure and evidence for a humanitarian actor to be providing information and at the same time without having to reveal the sources of this information. So in terms of disclosure, there is a possibility for the humanitarian actor to provide evidence. Now we need also to agree on what evidence means, because a humanitarian actor can provide information, and then the next step will be to know whether that information might lead to evidence that will be admissible by the ICC judges. But there is definitely a possibility for humanitarian actors to provide information and using existing mechanism not to have to testify.
Great, thank you very much. Another question coming in from Andreas asks, how much can we trust or use the information provided by humanitarian actors? Is it viewed as reliable and or trustworthy by the ICC? And here I'm presuming Andreas is referencing at the various points in terms of perhaps an investigatory stage versus a prosecutorial. But could you speak to this, Theo?
Yes, I mean that's an interesting question, because that goes back to the question of methodology. Of course, the more credible and strong your methodology is, the more chance you will have for the information you provide to the ICC to be considered as having a probative value. This is a case where, for example, if I'm not mistaken, in the Banga case, there was a discussion on how the prosecutor was using information, and in the case of humanitarian actors, which are clear on the methodology they use and spell out the various modalities and procedure they follow to collect information, this, for example, was a contributing factor to consider the information with more of the probative value. If there is no information on how this data was collected, this is going to be more complicated for this information to go through the process of being considered as having a probative value throughout the ICC proceedings.
Thank you very much, Theo. We have another question coming in that I think is a natural up. This is from Omnea. And Omnea asks, within the Rome Statute and perhaps the one on evidence, what kind of mechanisms might exist to encourage witnesses to testify or provide evidence? Do these include certain levels of protection for the witnesses? And if I could add on to this, Theo, could you perhaps also address, if the decision is made to testify or otherwise provide information, what might be the risks that a humanitarian organization would consider in making the decision?
Sorry, can you repeat the second part of the question?
Sure. The second part of the question would be, what type of risks or other issues would a humanitarian organization consider if and when they make the decision to cooperate?
Okay, thank you. Well, with regard to protection of witnesses, I mean, as you know, there is a series of mechanisms or measures that can be taken to ensure protection of witnesses with regard to confidentiality and anonymization of witnesses. That could be using audio recording. So there are measures in place to ensure that the ICC is delivering on its obligation to protect victims and witnesses. Now, of course, this is a very sensitive issue, and sometimes the ICC could be seen as too big of an organization with sometimes limited resources to actually fully deliver on all the measures that would be necessary to ensure full protection of witnesses. But this is definitely the mandate of the ICC, and there are measures in place for that. With regard to the risks to consider once you as a humanitarian actor, decide to cooperate, I think it depends on the type of cooperation. If it's about sharing information with the prosecutor under the condition of confidentiality to help the prosecutor get some leads or generate new evidence, that might limit the risk. So this mode of cooperation would be maybe the one with less exposure for the humanitarian actor. But maybe there's other type of cooperation where, for example, the humanitarian actor is in a position to provide information that no other people can provide. For example, through one of the staff, using one of the staff as an expert witness before the ICC. Of course, this would change completely the dynamic, because then even if the humanitarian actor is not concerned directly with the ICC in terms of its mandate, and it's more providing assistance, for example, to vulnerable groups. The moment this type of clear cooperation comes to light, of course, the humanitarian actor will not be seen as first of all focusing only on its activities, but when carrying out its activities, people interacting with them, and that could be vital interlocutors to get access to victims or vulnerable groups, would see this humanitarian actor as not being neutral or impartial, depending on how you define neutrality and impartiality.
Thank you for that. Another interesting question, Faya. Do many or any NGOs of humanitarian action have specific rules or procedures about the possibility and mode of cooperating with the ICC? So again, if you'd allow me to elaborate a bit, have you come across any organizations that in place policies that address this issue, both in terms of decision-making process, but also methodologies or best practice for information gathering and engagement?
Well, I would say, I mean, from my experience, I would say that maybe NGOs with a mandate that is closer to what the ICC is doing, where, for example, an NGO would be carrying out strategic litigation, so intervening in cases before different courts, either at the domestic level or at the international level. If this is part of its daily activity, then they would definitely have procedures, mechanisms in place to address the specific question of cooperating with the ICC, in particular if their role is to gather information as first responder in the field, that they know this type of information is critical for a successful process. Said that, I would also tend to say that some of organizations might not have this formally in place, but they might need to consider this to make sure there is a consistent practice in-house and to consider, if you want, all the implications based on what can be done and what can't be done and what the ICC will be doing as part of this cooperation. That's very important. And last point, maybe something we didn't address so far, is the fact that if humanitarian actors are the first responder and gather information from victims or witnesses, there is a recurring issue with regard to witnesses or victims being interviewed by multiple humanitarian actors on the ground for many different purposes. And then if that person is critical for the prosecution case, and that this person ends up being interviewed again by the prosecution in the context of an ICC proceeding, then if there is discrepancies between the testimonies provided, the versions provided by this person prior to being engaged in the process of the ICC, this might affect the credibility of the witness, because the defense could compare these testimonies before the ICC with maybe previous accounts of that same story, and see discrepancies as a way to undermine the credibility of the witnesses. So that's something also that needs to be considered. This being said, it doesn't mean that humanitarian actors should be adopting an international criminal law or criminal law procedure approach when they interview victims or witnesses. But that's something that should be kept in mind as a kind of preemptive approach.
Great, thank you. I think we have time for one or possibly two more questions. The one from Hugo, who writes in and says, am I right in understanding that apart exclusion of the ICRC by the Rome Statute, any humanitarian can be compelled to be a witness if their evidence is important and cannot be obtained in any other way?
I'm sorry, can you repeat the question?
Sure. So Hugo is asking for a clarification where he says, apart special case of the ICRC, can any humanitarian be compelled to be a witness if their evidence is deemed important and can't be obtained any other way?
Well, if you look at the ICC statute and the rules of procedure, compared to other to the ad hoc tribunals, for example, which had the power to compel witnesses to appear. Here, before the ICC, the procedure is more going through the mediation of a state party, so requesting the state to facilitate the appearance of a person. But there's also a need to consider that indeed, if this is valuable information, some would see the ICC statute and the rules of procedure as allowing for the ICC through a state to compel someone to testify. That's one thing. Then measures can be taken to ensure that for this testimony, the humanitarian actor staff will not be compelled to to share the sources of information, so it will benefit from confidentiality. And then there might also be measures in place to ensure this testimony might not allow for the humanitarian actor to be identified as such.
Great, thank you very much. I think we'll conclude with this last question from Geoff, who asks, is cooperation with the ICC, potential or otherwise, causing an expansion or contraction of humanitarian space?
Sorry again, the connection is very bad. I need to ask you to repeat.
Sure, I'm sorry about this. So Geoff asks, are the actions of the ICC causing an expansion or contraction of humanitarian space?
Yes, that's a very good question. In a way, you could consider that having the ICC as a permanent criminal court, of course, dealing with only a few cases, but being perceived as sometimes as the alpha and omega of the fight against impunity, and I think that would be another statement. Of course, from the perspective of people who are working on the ground, they might see this presence as a constraint in the sense that to the best of their abilities they can explain that they are different from the ICC, that they should not be confused with the ICC, but they can do that only to a certain extent. Then the perception can remain that there is a kind of informal connection between, for example, any expat working for a humanitarian actor and the ICC. So for that matter, the ICC could be seen as not restricting the space, but maybe forcing humanitarian actors to think more carefully of how they identify and define themselves in the context of carrying out their activities. Having said that, I think there's also a consideration that, I mean, there's many angles to look at that, but if the ICC is to act as a deterrent for further crimes to be committed, there is also a possibility that having the ICC as a permanent criminal court, despite all its limitation and limited resources, the ICC could be seen as maybe a way for humanitarian actors to operate in a context where having the ICC might ease some interaction with non-state armed actors, in the sense that they could see the presence of the ICC or the existence of the ICC as a reference point for which they would need to maybe gain more of a respectful stand, being seen more as an actor who is open to interacting with humanitarian actors, who is open to share information and take into consideration, I would say, imperatives such as protection of civilians. So for that matter, that could also play as a contributing factor that may help the work of humanitarian actors. But I'm quite realistic. I've been in many different war zones, and I'm aware that this is not the prevailing view. But I also wanted to conclude on a positive note, and I also take this opportunity to thank everyone who were there and also who asked questions. This was a very good experience for me, and I learned a lot, and I hope you learned from me as well. Thank you.
Thank you very much. We appreciate such an insightful and illuminating presentation. And again, apologies for the slight technical glitches that we experienced. As a reminder for those of you who are interested, the recording of this event will be available later today, along with the resources and the assessment, which is available for PHAP members. It's all available on the PHAP website at the URL below. And then as a reminder to those who are interested, our next IHL expert briefing will be on the 7th of December, and this will be on suppressing foreign terrorist fighters as a principled humanitarian action. And this is presented by Naz Mudirzadeh and Dustin Lewis from the Program on International on Armed Conflict at Harvard Law School. And with that, I'd like to thank Theo again, the team at PHAP, particularly Marcus Forsberg, and thank you to all for joining us today and for your wonderful engagement on this. I wish you all a pleasant morning, afternoon, or good evening.